Okay, we are now recording.
Okay, good morning, everyone. This meeting of the Agricultural Labor Relations Board is now called to order. I will first call the roll. Can please give a verbal present. Board Member Broad?
Present.
Board Member Flores? Board Member Flores, I believe you're on, but I can't see you or hear you.
Well, just a moment. I need to promote her and she will be able to join.
Wow, what power.
Apologies, Board Member Flores.
Present.
Thank you. And I believe Board Member Hall will be hopefully joining us later today. So moving on to Board Member Lightstone.
Present.
Thank you. Also present today is our Executive Secretary, Santiago Avila Gomez, who is providing our technical support. Our first agenda item is to approve the meeting minutes from March 5th, May 2025. March 5th, 2025. May I have a motion to approve?
So moved.
Thank you. May I have a second?
Second.
Thank you. Member Flores seconds the motion. All those in favor, say aye.
Aye.
Aye. The minutes have been approved. The next agenda item is the chair's report. I just have a couple of items. I am in receipt of questions from the Senate Rules Committee and have submitted my responses to those, and I will be preparing for my confirmation hearing. The date has yet to be set, but I anticipate it to be in the next couple of months, so I will keep the board apprised of that. On Monday, I will be representing our agency at the California Tribal Summit. This is an event that has been spearheaded by Governor Newsom to improve relations and how the public serves our tribal communities. And it's my first time participating in person, so very excited about that. And that concludes the chair's report. The next item is our executive officer's report on elections, unfair labor practice complaints, and hearings, which will be presented by our executive officer, Mr. Avila Gomez. Santiago?
Thank you and good morning again, everyone. I apologize. I'll add, before I commence with my report, I wanted to allow the board to consider addition and to its closed session agenda items pursuant to, Government Code 11125.3. You need to make a motion and vote determining that a matter came to you in late fashion after the initial notice went out and that it's being added to your closed session items.
Thank you, and thank you for that reminder, Santiago. I will make the motion that pursuant to the government code section referenced by Santiago, that we add Kind Farms Corp. Et al. 2023 CE001 Salinas region. This is a request for subpoena enforcement from the general counsel. May I have a second?
I'll second.
Thank you, Member Lightstone. All those in favor, please vote. Aye.
Aye. Aye.
Aye.
All right, the item has been added. Thank you.
You're welcome. Now turning to the matters that have come up since our last public board meeting. I'll start, of course, with matters pending before the board, and that would be the, of course, things have changed here on my screen. I apologize. Great. I'm having some technical difficulties. Apologies. All right. So let's start with a complaint that was issued by the general counsel, and I may be mispronouncing this, but it's Tauser Apiaries beekeeping matter, and that complaint was issued on March 6th. Matters settled post-complaint include OFR Inc., the wine group. There, that motion to take hearing off calendar was filed on March 7th. Another matter that was taken off or requested to take off calendar was filed in is in the Diorigo Brothers and Fanciful Company, and the case number there is 2023 CE 043 SAL. And that was filed on March 13th. And finally, turning to the matters that are pending before the board. And I apologize, I don't have the information right in front of me, but you had mentioned already the subpoena request enforcement and Kind Farms as well. There is Zabala Farms. It's an ALJ decision that issued on default. It's pending exceptions, if any, to be filed. And today, with the effective date of today, although filed shortly after the 5 p.m. deadline yesterday, Wonderful Nurseries filed a request for a special appeal, which will be circulated to the board. That concludes my report, and I'm happy to answer any questions.
Thank you so much, Santiago. Appreciate it. I don't have any questions. Do any of my colleagues? Okay, all right. Next, we will check in with our Chief Board Counsel, Laura Hike, to see if we have any updates on litigation.
Good morning, Chair Hasid and board members. We do have a few updates. In one of the cases pending in the 5th District Court of Appeal, that's case number F088515 and F088520, the consolidated matter that's basically it's the ALRB and UFW's appeals of the Superior Court order granting preliminary injunction. Opening briefs on appeal were filed by the board and UFW on February 7th. Wonderful's answering brief was due by March 10th, but the court website shows they haven't filed yet, anyways, as of yesterday afternoon. So they appear to be under the 15-day grace period allowed by court rules. That 15-day period ends March 25th. Once they file their brief, the ALRB's and UFW's reply briefs are due 20 days after that date. In the matter in Federal District Court, Wonderful Nurseries LLC versus ALRB. That was filed on December 30th. There's a few updates. Remember at the last board meeting, we had the development of the UFW withdrawing its request for MMC. And as a result of that, on March 14th, our team at the DOJ reported that the court took off calendar the individual employee's motion to intervene in the matter. This was a motion to intervene filed on February 3rd. These are wonderful employees represented by the National Right to Work Legal Defense Foundation. That was set to be heard on the 17th of March. However, like I said, in light of the UFW's withdrawal for the request for MMC, that matter was taken off hearing, and the court will decide it on the papers. With respect to the preliminary injunction filed by Wonderful, they have withdrawn that motion and also in light of the UFW's withdrawal of the request for MMC. So at this point, the only thing pending is the board's response to the complaint, and that's due April 1st. That was a lot. Any questions? Okay, and then finally, in Chavez et al. Versus ALRB, this is case number BCB-25-10064. 2449, a matter in Kern County Superior Court. The board was finally served with the complaint in that matter on March 6th. And the board's answer to the complaint is due April 7th. And that concludes my report.
Thank you. A lot going on. Appreciate it.
Yeah, there's a lot, there's moving parts in the federal case, and I expect we'll get some updates on that soon.
All right. Do my colleagues have any questions? Okay, thank you, Laura. Appreciate all your hard work. The next agenda item is the General Counsel's report with General Counsel Julie Montgomery. Julie? And I think Santiago, she might be participating virtually, so you need to promote her as well.
Working on it now. Oh, sorry, wrong Julie. Here we go. Sorry about that, General Counsel Montgomery.
Good morning. Can everybody see and hear me?
Yeah.
Great.
Yes.
Good morning, Chair Hasid and board members. For my report today, I will talk about a couple of settlements in our regions and give you a little overview of some of our outreach events since the last meeting. First of all, I'm happy to report that our Region 2 teams entered into a settlement for the with the Wine Group, Inc., which our executive secretary mentioned in his report. In that case, 2 vineyard tractor drivers in Fresno County filed unfair labor practice charges between June and September of 2023, alleging that the Wine Group retaliated against them. And this included terminating them when they complained about mistreatment from a coworker and a former supervisor and lack of hand washing soap. The ALRB filed a complaint against the Wine Group at the end of 2024 in December, and the workers were also offered reinstatement to their positions at some point during that process. And then thereafter, the parties entered into a settlement agreement to fully resolve and settle the complaint on February 27th of this year. And the Wine Group will pay the workers a total of $35,817 in back pay, and as well as allow for the standard noticing remedies and supervisor training. So our ALRB regional staff will be going to the Wine Group and training their supervisory staff about the ALRA and their workers' rights and companies' obligations. And then for Region 1, our staff achieved a settlement agreement involving Dorigo Brothers of California and Fanciful Company, Inc. And this case involved a cauliflower harvester in Monterey County who filed an unfair labor practice charge in November of 2023, alleging that Dorigo and Fanciful retaliated against him when they terminated his employment after he complained about the speed of a cauliflower harvesting machine, lack of cooling breaks, and failure to pay correct wages. And the ALRB found that there was a violation and filed a complaint against the companies on December 20th, 2024. And then the parties entered into a settlement agreement to resolve all the claims on March 13th of this year. And the companies will offer the charging party reinstatement, pay him $17,000 in back pay, as well as the standard noticing remedies. So kudos to both regions for achieving these great results for workers. Any questions? Okay.
No, thank you.
In addition, our outreach staff has been busy at work, and I'll just give you a little overview of some of their activities. We had staff presenting at a youth meeting through migrant education in Riverside County about farm workers' rights in the ALRB. And they also distributed materials at a Know Your Rights Immigration Forum hosted by the Monterey County Immigration Rights Ad Hoc Committee in the city of Pajaro. They distributed materials at an event called Burritos con Derechos, so burritos with rights, hosted by Valley Forward, the Jacara Movement, and UC Merced Community Labor Center in the city of Biola, which is in Fresno County. And our staff also trained workers at CBDIO's monthly meeting in Lindsay in Tulare County, which I think I had mentioned last meeting that they were planning to do. And they appeared at a television interview for Telemundo in the city of Thousand Palms in Riverside County, where they discussed workers' rights that the LRB enforces. And they also discussed some recent case successes and settlements in that region. So that was some nice coverage by Telemundo. And our staff also distributed materials to workers at their workplace in Imperial County, and this was in collaboration with EDD and CRLA, which is California Rural Legal Assistance, nonprofit organization. And then staff also distributed materials at the Superhero Resource Fair, hosted by Lamont Elementary School District's Family Success Center in Kern County. And then finally, they tabled and distributed materials and did a short presentation at the Immigration Know Your Rights workshop hosted by United Farm Worker Foundation in Indio, which is in Riverside County. So as usual, staff have been busy at work in the communities, working with nonprofits and other government organizations, and bringing information and resources to workers through various parts of the state. And that concludes my report for today.
Thank you so much, Julie. I appreciate your work and the work of the staff in the various regions. So thank you. Do any of my colleagues have any questions? Okay, we do not have an administrative services report today. I do have a brief update on legislation. There was a bill, AB 552, by the chair of the Assembly Labor and Employment Committee, Assemblymember Ortega, that was amended last week to amend sections in the ALRA regarding our headquarters location. We have reached out to the author's office. We believe that may be a spot vehicle for something else, but we are monitoring and we'll keep everyone posted. We're not aware of any specific ideas. We do not have a regulatory report. So next we will go to our main update for today, which is our informational panel. I'm pleased to share that today we have a wonderful panel discussing farm worker wage collection issues. I will introduce our panelists and then turn it over to them. First, we have Tia Kuntz. She is the Legal and Policy Research Manager at the UCLA Labor Center. In this role, Tia supports the UCLA Labor Center's initiative, Rework the Worker Justice Institute program. She has 15 plus years of legal and policy research in employment protections in low-wage industries, as well as anti-discrimination and retaliation regimes. Tia provides data, policy analysis, and budget recommendations to a wide range of nonprofits, government agencies, and legislative bodies to improve working conditions across the state. She is joined by Justin McBride, also of UCLA. Justin is a labor studies scholar and writes about public finance and the intersection between public policy and worker organizing. He is the project director for the UCLA Strategic Research Lab. His current research focuses on wage theft, the history of strategic campaigning in the US labor movement, and organizing efforts in the nonprofit sector. Justin previously served as the director of the Clean Car Wash campaign in LA and was an organizer with SEIU's Justice for Janitors division. Last but certainly not least, I'm pleased to share and introduce my former colleague, Matthew Ciroli. He leads a small team of attorneys in the California Labor Commissioner's Office, which litigates cases at the convergence of workers' rights and creditors' rights. In addition to labor code enforcement, this team focuses on helping workers collect wages by fighting corporate shell games, unwinding fraudulent transfers, asserting workers' rights as creditors in insolvency proceedings, and advising staff on the enforcement of judgments and liens. Mr. Ciroli is also a member of the Labor Commissioner's Agriculture Industry Strategic Enforcement Partnership Team and has litigated cases to enforce farm workers' rights in bankruptcy court. Thank you so much. I'm so pleased to have all of our panelists today and just to get to learn from each of you kind of what you're seeing out there and see how we can improve and have that inform our work and the work of our staff. So with that, I will turn it over to you. I believe, Tia, you are going to be kicking off this discussion.
Fun fact, I'm going to turn it over to my colleague, Matt, who has just the most excellent framing for all of this. But thank you for that lovely reception, everybody. I'm not sure who else is on, and we've not spoken to this audience before, so it's really nice to be so warmly received. Also, shall I share my screen, or who wants to? We created a PowerPoint, you guys. It's so good. It's really exciting. But I'm not sure how we share it.
I will, Santiago, can you advise, should Tia share her screen or do we have it? I think we have a previous version. I don't know if we have the latest and greatest.
They're authorized to share, so tell me your preference. I can pull up the PowerPoint that I have and we can use that, or you can share your screen.
I'll just share my screen. One does so love to share one's screen. All right. Okay. We should
great.
be. All right. Are you guys
can
seeing the
see-
entire screen, or are you just seeing the?
We see it as a square, but we can read it, or at least the headlines we can read.
I can fix that. Give me just a moment. Thank you for your patience with me. If it can go wrong, it will go wrong, and that's just how it is.
And that is the old version, Tia. You have the new version.
It is not, in fact. Oh, wait, no, it is, in fact. You are correct. Thank you.
The new version has much nicer formatting, which I can't take any credit for, but
I'm embarrassed to say that I used AI. Okay, I'm going to do a portion of my screen share. Here we go. I have to,
Oh, it says it's launching. There we go.
yay, fantastic.
Yay. And I'm gonna mute our room just so we're not creating any background noise and shut our door here just again, so we're minimizing background, but go ahead and start when you're ready.
Take it away, Mr. Ciroli.
okay. Well, thank you, everybody. Thank you for having us. Hopefully we will have something useful to add to the great work that you guys do. And thank you for the kind introduction. I've been doing this work at some level now for 20 years almost, meaning that I've been trying to enforce workers' rights in low-wage industries where there is not only endemic wage theft, but endemic corporate fraud. So essentially endemic misuse of the corporate form to try to evade payment, which is very common in low-wage industries, as many of you probably know. I have not done much in ag until, or I had not done much in ag until about 5 years ago when I joined a team in the Labor Commissioner's office. So I've learned a lot about the agricultural industry and it's been interesting. So without further remarks, let me go move on to the first slide, Tia. So I'm gonna start here because after doing this for 20 years, there's something that really does strike me as important, and forgive me if this seems pedantic or silly or just about terms, but to me it's really, there's an important framing issue here that I think is conceptually kind of important, and we run into it a lot in the workers' rights world. So the big framing that I want to get at here at the beginning is that collections, right, trying to get money to workers, and for that matter, getting compliance, that's not something that one does when they get a judgment. When you get a judgment, you do something called judgment enforcement. Like that's literally how it's written in the Code of Civil Procedure. It's the enforcement of judgment law, not the collections law, which makes sense, right? As I often kind of jokingly say, you don't want to collect judgments because that would just mean you have a bunch of judgments that aren't paid. We do far too many collecting of judgments. We want to collect money, right? Not judgments. And how do you collect money? Well, you do that from the get-go in a case, right? And that is not just some sort of cute thing with terms. That is really accurate in terms of creditors' rights law And this is why it's important, why we titled this Creditors' Rights Are Workers' Rights, because workers are creditors. Workers owed wages are creditors, right? Workers are always creditors. Presumably workers owed back wages after an ALRB proceeding are also creditors, right? So creditors have certain rights. Big picture, those rights do not depend on them having a judgment, right? A judgment can be useful, it can do useful things, but the vast majority of creditors' rights law depends on you having a claim to money, not on you having a judgment or a liquidated claim to money. And this is important framing for very practical reasons, right? But just to start and back up big picture, like I said, workers are always creditors, whether they have a judgment or not. And I mean that like literally, they can make claims in bankruptcy court. They can often make claims in escrow. They can do all kinds of things to get paid long before they have a judgment. And of course they can, right? Because all of us get our paychecks not by going and getting a judgment every month or 2 weeks so we can get our paychecks. We're creditors, we're owed money, because we're owed money, not because a court or an administrative body says that we're owed money. Collections generally, and I know it's a little bit more complicated than this, but this is again an important point because I think it leads to a lot of confusion in both how we sometimes do these cases and then sometimes in how we create policy around the cases. So collections generally means pre-judgment work, right? A bill collector is somebody who calls you up and says, I'm going to sue you if you don't pay your credit card bill, right? So after you've gotten a judgment, you're sort of done collections. The normal collections part, that's not when you start being a bill collector. That's when you're done. You can't say, I'm going to sue you again, right? That part's done, right? And it makes sense because bill collectors and honestly, a lot of the tax authorities, they focus really for financial reasons. It makes sense to do this for financial reasons on high volume, low effort cases. In other words, people that you can scare into paying without having to use too much legal process, right? Judgment enforcement is kind of the end of that. So it's certainly part of collections. You're trying to collect money, but it's kind of after normal collections that you would think of as collections, bill collector stuff has failed. Now you need to do judgment enforcement, right? And I think some of the attorneys here are probably well aware of this, right? But judgment enforcement involves using legal processes, really. So you're past the point where the employers or the debtors are likely to be scared by your threats, right? All those people got weeded out at the beginning of the case. They're no longer scared of your threats. You can threaten them all day long and they'll say, yeah, right. Let's see what you do. Right? So what do you do, right? So judgment enforcement really, at some level, it's very simple, and we're going to get into this, but it has a lot of holes in it. But the very simple part is at the end of the day, how does the civil procedure expect that you'll enforce the code of civil procedure expect that you'll enforce a civil money judgment? It says, well, what you can do is you can take anything, not anything, but you can take a lot of the assets, a lot of the property that the debtor owns, if they own property. If that debtor that's on the judgment owns property, you can take it and you can sell it. That's how you enforce a judgment. That's it. That's a little bit of an oversimplification, but that's basically how the Code of Civil Procedure works. There is an interesting upshot of this when you're dealing with low-wage industries, as I have seen over the last 20 years and even more in the Labor Commissioner's office. It may well be in a lot of these cases, because what we're really doing is enforcing the law and vindicating workers' rights. We're going to put way more resources into getting money than the amount of money we get. It was not uncommon to spend 100 hours on a $50,000 case. The amount of attorneys' fees involved are way higher than the money that we get back. It doesn't make economic sense. It makes law enforcement sense, right? What we're really doing is trying to make sure the law is enforced and vindicate workers' rights. So anyway, and that may mean in some of these cases, not just getting money, it may mean shutting a business down, which I know you guys are doing too through injunctions, but shutting down a business that is unfair competition. And with that, that sort of big framing, I'm going to pass it over to Tia.
Thank you so much, Matt, which is why we titled this presentation, Creating a Culture of Compliance, Creditors' Remedies Are Workers' Rights. The goal is getting to compliance, right? It's getting to collections. It's getting that money. It's not getting to judgment. That said, before we go on about legal tools, et cetera, I want to level the playing field and make sure that everybody understands the vocabulary, the very specific, discrete vocabulary of collections. And just as a modern American, you're already familiar with all of these things in the way that we live and breathe and do our job. If you have a car, you're familiar with a lien because you've probably got it financed before, right? So a lien is just a hold on your property. It's a passive remedy. You don't have to have a judgment to get a lien. You can get a lien beforehand, and we'll talk about how. And liens are actually a lot stronger than judgments because they place a hold on that property right away so that the person who has that property can't sell it without no new buyer is going to want to buy a property that has a lien on it because you can foreclose on that lien and then you can take that property. So you're familiar with this if you have a car, you're familiar with this if you have a mortgage and you got financed for it, right? The bank or the car note, whatever you bought the car from or who financed your car note, they've got a lien on your car. They've got a lien on your house. That doesn't mean they drive your car. That doesn't mean they live in your house, right? It's a passive remedy. It's a hold. But they could sue to foreclose on a debt if you stop making your payments, and then they could take it away from you. So a lien is an exceptionally powerful property or a powerful tool. And the other thing about a lien is that it doesn't matter how big or how small your claim is. Your claim could be $300 for a day's labor or a couple of days labor that you performed as a day laborer, or it can be a much bigger amount. The effect is the same. You place a lien on that piece of property and they can't sell it anymore, and you can still actually foreclose on it, even just to get your $300 back. So that's a lien, right? A mechanic's lien is a special kind of lien that's available for construction workers. If you've improved the value of property by working on it, you've got a mechanic's lien available to you. It's the same thing as a lien, except that it's available before a judgment and it's in the code. So it's a pre-judgment claim on property. As soon as you do the work, this claim arises and you're able to go file that mechanic's lien on the property if you don't get paid, right? There are also, as a lot of you guys are probably familiar with, because this is the Agricultural Labor Relations Board, crop liens in the code, right? And we're going to talk about how effective liens are. We're going to talk about how effective mechanics liens are in particular. I can't say the same about our crop lien regime. Crop liens are a pre-judgment claim on your harvest, right? And they're in, I've put the section of the code in there. They're in the civil code at 3061.5 to 0.6. And unlike most states, though, our crop lien is really limited. It's only against LLPs, which is a kind of a business association that most farms aren't using. And so it's not as effective as mechanics liens or as effective as it could be, but they exist, these kind of pre-judgment liens that arise as soon as the labor is performed. Now, a claim, I just want to make sure folks know a claim. I use the icon of a flag. A claim, just you're owed money, right? You have a little flag on something. In the creditor's rights context, judgment is almost never required to assert rights. So it's a claim that you're owed money. You don't need a judgment to file a proof of claim. So I'll say that again. You don't need to get to the proof part. You don't need to get to the part where you've proved, beyond, you've made your case that in fact you are owed that money in order to just file a claim. You don't need a judgment to pierce the corporate veil. That's underneath the corporate code or in court under equitable kind of doctrines or remedies. And you don't need a judgment to file a motion for receivership claim, right? You don't even need a judgment to demand payment from escrows in a number of different situations, like say, for example, taking somebody's liquor license if it's a restaurant. So I just want to make that clear for folks. A claim arises when you're owed the money. And then finally, the term levy. Levy is an active remedy. So I chose an icon of a guy running away with your money. That is what a levy is. A levy is actually taking that money. And we're going to talk about creative ways to levy in order to be able to actually get to that collections. But it's a seizure of your cash from the bank or a seizure of property to be sold to pay for judgment. You can only do a levy in a post-judgment world, okay? It's only useful if your judgment debtor, your ne'er-do-well employer, which is the exact entity or person on the judgment, so this is after litigation, has enough assets that can actually, if you were to get them, you could pay all of the workers for what they're owed, right? So these are just the key terms we're going to be working with. I want to talk a little bit about how to use them. So think of creditors' rights. Like a worker is a creditor. A worker has the same rights, for example, or a worker should think of themselves, and we, on behalf of workers, when we're representing them, should think of workers as having the same kinds of claim over those wages as a bank does, or a lender or a credit card company, right? These are just creditors' rights. So if we think of creditors' rights as a strategy to get to that compliance, the very first contact with the employer is going to open the door. So the very first contact is opening the door to settlement. You want to settle first, right? The final judgment is often represents a failure. They've ignored you. They haven't been willing to settle. You haven't presented enough leverage to get them to finally pony up. Sometimes I liken this collections or judgment enforcement to making a teenager clean their room. Like, they're old enough to call your bluff. You can't physically force them to clean your room anymore. So you have to think going into that conversation about all your different points of leverage, right? There are opportunities to raise settlement every single time you get any more information. And you have to research, right? The big picture is you want the other side to pay some money. You want to change in the working conditions. Sometimes you get a judgment. Sometimes you settle. Sometimes you sue for a stop work order, or you get a stop work order and shut down recalcitrant bad actors, but it's almost never by getting to a judgment. So don't wait until that point. And then ironically, most money judgments are the most useful to stop bad actors, not for actually collecting any money. The primary thing a judgment does is give you the power to take those assets, to do the levy, right? To levy those assets and money streams. So if you exercise that power with a really big judgment, you inevitably force the business to shut down or hide or go into bankruptcy, or strategically outmaneuver you by reincorporating or other such moves. That's going to require a whole lot of research and money on the back end in order to unwind whatever those false shell companies are, et cetera, and drag that money back. To get a good settlement, you want to build your leverage early. You want to assert those creditors' rights, assert those remedies early, pre-judgment wherever possible. So you want to talk about liening. You want to find whatever property you can, get liens on it as quickly as you can, right? Now let's talk a little bit more about how to think like this creditor, about how to name every person you can and locate, be a detective to locate any of the tangible assets, anything that you can actually use in order to get those workers paid. So first, name any individual you can, right? So I'm sorry if the font is really small here. It is on my computer, but that's individuals. That's going to be your joint employers, right? That's going to be any shareholders or officers, successors, if they've sold the business or opened up a shell corporation and transferred that to another company. Any sureties, which is money that somebody's guaranteed they're going to pay that money. You want to reach out and make sure that that surety knows. And then you want to locate any source of asset. So that's going to be real estate. That's going to be like accounts receivable, any income. That could be liquor licenses. So even if a restaurant itself doesn't have a whole lot of assets, if it's got a liquor license, that is extremely profitable. Liquor licenses are rare to give out. We're not giving out a whole lot of new liquor licenses. And so you can actually file a motion for receivership and take that liquor license to go sell on the open market, right? And then the ways that you actually secure those assets. So once you've identified anything that that employer has or anything that that defendant has that you might be able to use in order to get your workers paid, the way that you claim those assets, that little safety pin, is you go file for a lien. You file a motion for receivership, which is where you take something like a liquor license and it's held by a third-party receiver until the debt's paid. And if the debt's not paid, then it's sold, right? You can attach to property, you can get a surety bond, talked about receivership, any of that leverage. You could also think about license revocation. So we've learned that in home care, many facilities need a Medicaid license, for example. Public works contractors can get debarred, which can put them out of business if they've consistently refused to pay settlements or pay judgments. And then you can think about how to actually levy creatively. So if you do get to a judgment, you've got a few kinds of levies available to you, right? So again, levy is the active remedy. You can levy by mail, which means that if you know the bank account, if you know the bank, the actual financial institution, the account number, you can use the mail to just get that money directly out of that account and into the hands of the defendants, the creditors, right? Not the defendants, pardon me, the creditors, the workers. You can also send a sheriff out to do a till tap, right? Which is just tapping the till for that day if it's the type of business that actually has money at the end of any given day. Matt, go ahead.
Just one quick clarification. So only the labor commissioner can levy by mail. Unfortunately.
Pardon me, yes, Matt, when I say you, I mean Matt.
You mean me
And
personally?
that's a
That's right.
rule 588.1. Only the labor commissioner has that ability. But you can do a till tap. And you can do what's called a keeper. So if it's the kind of business where you send a sheriff out and instead of the money going into the register, the money goes into the sheriff's hand, and then the sheriff takes whatever is collected at the end of the day and gives it to the creditor, right? If you're creative with how you use your levy, you may have to send the sheriff out multiple times until you get to the amount that's actually owed. And then finally, always think about bankruptcy, right? So get a lien, get some kind of security ASAP. So your creditor, workers can take their place in line in bankruptcy court. Bankruptcy doesn't have to mean the end of the world for a worker who's owed money, right? Workers are creditors and they can get in line in bankruptcy proceeding. Matt's going to talk about that in a second, but I just want to pause and see if there's any questions. There's no dumb questions. Some people on this call, I imagine, are really familiar with a lot of these tools. And some people on this call, this is the first time you've learned the difference between a lien and a levy. A lien, which is a passive remedy, a levy, it's an active remedy. Questions, comments, feelings? Okay, then I'm going to turn it to Matt to talk a little bit about thinking about settlements. We've encouraged folks to settle early and often before waiting for judgment. So think about how your case is going to end and what your leverage is.
Hey, I'm sorry to interrupt, Tia.
Yeah.
It appears that our Sacramento conference room has dropped off.
I
will-
wondered.
Let
Okay.
me, oh, I see. I need to promote them to panelists. Hold just a
Okay.
moment.
Okay.
Thank you.
Terrific. No problem. No problem.
Okay, I got so excited to unmute, I hit end call.
Did you unmute because you had a question?
Yes, I think several of us have questions.
How delightful.
So I have so many questions, so I'll try and give a pertinent one now. When you're saying levy, and I appreciate that only the labor commissioner can levy by mail. Oftentimes in our cases, we assert liability first. The liability for the unfair labor practice charge or the violation of the act. And then we go into compliance where we have a whole process where we determine how much is owed. So once we have that amount, at least as the general counsel or the regional director has determined, how would we actually go ahead and get a lien? Or do we have to have something like a final determination that has been found to in fact be owed?
Matt, go for it. We're exactly the people to answer these questions.
Yeah. So first off, and I think you know this based on the question, but just so everybody knows it, you would not be able to levy without a judgment. That is the one thing that you need a judgment for. In some ways, one should think of judgments as the power to levy. It's actually literally it's called under the enforcement of judgments law, execution of a judgment. How do you execute a money judgment? You levy. So you couldn't levy. Liens are what you got pre-judgment and attachments, which
Yeah,
are
liens,
kind of
attachments, anything, a receivership,
right.
something.
Attachments are essentially kind of pre-judgment partial levies. But so what could you do pre-judgment? You can get liens if you have the rights to liens. From what I know about the ag context, other than the crop liens, there's not a lot of places that give you instant rights to liens, but they could arise under certain circumstances. And probably the most likely circumstance would be a bulk sale under the UCC, which it's not clear that a grower engaged in a bulk sale would be subject to the, or would have to follow the bulk sales requirements under the UCC, because it generally applies to businesses that deal in inventory and restaurants, but they might follow it. I think we saw one where they actually did, and we put in a claim. And what that involves essentially is that, you know, when let's say a grower is selling off all their assets, maybe they're retiring, they're selling it to a new grower, they're selling it to a different, you know, to a bigger company that's consolidating. They're generally going to do that through escrow. And if you put in a claim in escrow under the Bulk Sales Act, at least, you have a right to be paid. You don't need a judgment, or you have a right to be paid. They can object to your claim. So don't get me wrong, right? There's due process. People, the employer or the defendant or the grower has the right to say, no, you're wrong, right? But you put in a claim, and then the way the UCC sets it up is that if they disagree with your claim, then you have to go to court, and you basically get an attachment. We've done that actually fairly recently in the restaurant context in a case where a restaurant was being sold. We had an investigation. We had actually yet to issue a citation, but we knew that amounts were owed, right? We were pretty clear on the amounts owed. We just didn't have an exact liquidation of the dollar amounts. So we did a claim into the bulk sale and to escrow under the Bulk Sales Act, and got about $250,000 sitting in escrow, right? So now what's happening is that $250,000 is there. It's captured. They're not getting rid of it. We're still litigating the claim, and it turns out that later on, our auditors determined that actually more like 500,000 was owed, which would have been nice if we knew it ahead of time, but we didn't. So, but at any rate, at least $250,000 is escrowed, and so while the case is being litigated, we've got that money sitting there, right? So we know at least $250,000 is captured, and we're not going to lose that money. So that's sort of an example of how it works under the Bulk Sales Act. There's some places where, I mean, you know, I don't know that it would apply to ALRB findings. You guys are certainly going to know that a lot better than I do, but there are some places where there are also insolvency liens, most specifically under Code of Civil Procedure 1204 and 1205. So those both create liens and potentially super priority claims on amounts on wages owed for 90 days of work before a business shuts down or sells everything. And those are ones that you can assert pre-judgment as well. I would suspect that for the ALRB claims, at least under existing law, and I'm not an expert on how it applies to ALRB, but I would suspect you're mostly limited to either receiverships or maybe attachments, though there might be difficulties with attachments because it usually has to be a claim based on contract.
So two things, just as a quick summary. So number one, Matt has just given you a ton of very technical ways to encumber property, right? And so we're here for you. If you have follow-up questions, follow up with us on what those different encumbrances might look like. And then 1204 and 1205 getting super priority in line. But the other piece is, you know, there are crop liens available. So if it's an LLP, getting a lien on the harvested crops is available. So I don't know how often you guys use it, because most of the farms themselves are not actually LLPs. But I just wanted to flag. And then that is, I mean, the way that the law is written, crop liens are available for LLPs. If the law were expanded, or if that just provision about limitations to LLPs were removed, then it would be a much more accessible form of a prejudgment lien that would be available right away. Cynthia, I see your hand up. Go for it.
I have also many questions. I know we're we're just starting, but just generally speaking, and hi, Tia, it's nice to see you.
Hi, Cynthia.
I'm just curious to see, in your opinion, what is the most effective manner to recover damages? I imagine it's probably case specific, but generally speaking, kind of what is the most effective tool to get there?
I have a slide on that. I was gonna turn it to Matt to present, but it's a prejudgment lien. It's a mechanics lien. And the reason that I say that is because the data bear it out. So the data from a pilot project we started at the Labor Center, with our friends Oscar. And back in the day, in 2018 to 2023, the labor commissioner has been filing mechanics liens aggressively. And then we see a couple of other states that have that type of a prejudgment lien available, not just for construction work. And Justin's going to share with you guys the data on the efficacy of that tool in Washington state. It's also available in Wisconsin.
And actually, that does remind me of something I meant to say, which is a practical tip that could perhaps be used by the ALRB. Maybe already is. I don't know. But in settlement agreements, and it sounds like you do a fair amount of settlement agreements, which makes sense, right? At the end of the day, as I was going to say before, all right, almost all cases end by settlement. Having dealt with thousands and thousands of post-judgment cases, I can tell you, even post-judgment, almost all cases end in settlement, right? That's usually how like a war, that's usually how a case ends, is with the settlement. So with settlements, though, if they're not immediately coming into compliance or immediately paying all the money, we have found, and we're doing kind of ubiquitously in the labor commissioner's office, that it's good to get liens as part of the settlement. Because remember, the settlement's a contract. And just like any other contract, like money being loaned from a bank, you can ask for liens. You can ask for deeds of trust. You can even ask for UCC liens, which are against equipment and inventory and things like that. You can ask for that as part of the settlement agreement. And that gives you a lot of power. It gives you a lot of power because if they stop paying, you can foreclose on those assets and sell them. It gives you power because if they go into bankruptcy, you're now a lien creditor, and lien creditors at the very top of the pile in bankruptcy. You go before everybody else. And so it's a lien, as far as being a creditor, is your most powerful tool. It's why banks want liens when they loan you money.
Yeah,
Not
that's
stipulated
why
judgment.
any lender is gonna want to have a lien when they give you that money. It's
and I
just the
have
most
often-
powerful.
And I've often run into defense counsel will be like, no, we'll give you a stipulated judgment. It's great. That's way better. Like, you
Get a
are
lien.
out of your mind. I want a lien. You can keep your stipulated judgment. I mean, not that we sometimes put those in there, but really the lien's the tool that if you have the power to get it,
Yeah.
it gives you
Thank you. Yeah, thank you for asking those, Cynthia, because I know we're throwing out a lot of terms. So like, if you take nothing away from this, pre-judgment wage lien, that is the
Yes.
thing. And then Michaela, you said you had a bunch of questions. You asked one, and then we talked for a half an hour.
I'm gonna hand it over to my colleague Barry, because he's got.
So are you aware of any circumstances in agriculture where water rights have been liened? That's the nuclear option, by the way.
Excellent question. I personally have not done that. I don't know, Justin, Matt, are you guys aware of water rights being liened? That's an amazing asset.
I have not, but that is a good thought. I hadn't even thought about it. Yeah. I mean, so far we haven't had enough cases where we actually had to deal with that in the ag industry. But that's brilliant, because water rights are probably one of the most valuable things in the ag
Yeah, just as a follow-up, what we see in agriculture in circumstances where it's fairly common in our cases that the assets are divided up into different entities. So the employer of the workers doesn't have much in the way of assets. They're fungible. So they could just go out of business and, the workers are stuck. Obviously, the thing that they really need to hold on to are the water rights, because agriculture is not worth anything without water rights.
Totally.
So, if we really wanted to collect money from recalcitrant growers that don't want to pay, it would be get to the water rights. Now, it's not likely to be owned by the employer, but by some associate affiliated entity, which makes it a lot more complex. But if you could help us understand whether
Yeah.
water rights are
Yeah.
susceptible and all that, that would be important.
Well, and then what the relationship is with whoever the entity is that holds the water right to the employer, because it could be that they fall under joint employer, or it could be that there's some up the chain liability so that you would be able to attach. But yeah, that's a great pain point, Barry, that you like observed, right? When we say leverage, it's all the pain points, and in ag, I guess water rights is going to be a big one.
Yeah, no, and it's 100% right that the companies often are dividing up assets from the entities that employ the workers. I mean, we see this in the labor commissioner's office across all
Sure.
industries. It's
Yeah.
very common. It's become, I mean, I say this sometimes to folks, when you're thinking of a company, you know, this company, one company, you're really talking about 5 to 7 entities, right? That are separately on paper, all separate, and it's done strategically, you know, and in fact, it's a standard thing that
Yeah.
lawyers do. I've even seen it in some of the practice guides, you know, with corporate lawyer, you advise, you're trying to essentially strategically divide up debts from liabilities so that if you get hit with a big liability, you don't have to worry about satisfying that and you get to keep your
Sure. Yeah, that's the
assets.
story of business associations and corporate law for the last 60 years. Yeah.
Right. And, you know, and at the end of the day, I guess what I've found that's often most effective there, and I wouldn't, it'd be case specific, but often single enterprise liability starts to come into play because what happens is keeping them completely artificially separated is hard. So there starts to be sort of enough overlap that the case law around single enterprise liability applies.
Okay, friends, I'm mindful of time. And so I think I know that there are other questions and I want to get to them, but we have a lot more to talk to you guys about. So maybe.
Yeah, we'll defer.
Okay, maybe
to
we can
you.
turn it to Matt to just talk a little bit about bankruptcy, and then to Justin to talk about what we know from the data about the applicability of prejudgment liens in other states.
All right. So insolvency, this talks about both when there's not a bankruptcy and when there is a bankruptcy. We already talked a little bit about when there's not a bankruptcy. So I mentioned some of this, so I'll skip over that. When there is a bankruptcy, one of the things that I have found is we shouldn't think of bankruptcies, people who are enforcing workers' rights shouldn't think of bankruptcies as a bad thing necessarily. They can often be a great thing. I sometimes I love them. I'm like, ooh, you filed for bankruptcy. This is great. Now the court has control over all your assets and your books are open to me and I want to see everything, right? And I have more than once had bankruptcy cases where once we start getting into it, the employer's like, oh no, let me out. I didn't realize it was like this. Oh no, I want to dismiss my bankruptcy. It says, no. We asked the court, please don't dismiss it. The court says, yeah, no, I'm not dismissing it. We're controlling. We're going to pick this apart and see, you know, basically how your assets are getting fraudulently transferred and how that money can come back into the estate to pay creditors like workers. All right, so it is a way to collect money, bankruptcy, right? Keep in mind, in fact, traditionally it's a creditor's remedy, not a way to protect debtors, but it was something creditors used to do to try to get paid. No judgment is needed. This is super important, right? You never need a judgment to have standing in bankruptcy. You need a claim that you're owed money. That's what gives you standing in bankruptcy. A lien is much better, as we mentioned before, because that puts you at the top of the pile, but you may or may not be able to get a lien. But if you have a settlement and you got a lien through your settlement, you're going to be in great shape. So that you want to get that lien through a settlement when you're settling. And by the way, let me mention, because this goes a little bit towards the question about water rights, you can get a lien on anything voluntarily, right? So it has not been uncommon in cases where we've settled to say, well, we don't have a claim against this entity, but it owns the warehouse where these trucks are located, and we know you control that entity, so give us a lien against it if you want to settle. And then, okay, fine, here's your lien, right? They do it for a bank, they do it for us when we have enough leverage. All right, proofs of claim. You always want to file proofs of claim where you can. Some cases you can't because it's no asset, but you always file it. You definitely don't need a judgment. All you need is a claim that you're owed money. It's not unfair because people can object to your proof of claim if they really disagree with it, and it gets decided whether or not it's accurate or not. Usually people don't object because at that point, that's not really where the action is. They're fighting over what they can pay, not whether the audit is exactly right or the calculations are exactly right. And then there's a bunch of litigation that can be done in bankruptcy, and we've done this sometimes. Non-dischargeability is an interesting one. You can fight the discharge of certain debts, and I've done this. We're doing one case right now in the ag industry, and we did another one before that have led to permanent injunctions issued by the bankruptcy court, which is a federal court, against certain farm labor contractors ever operating again. So I've found it even a good place for compliance.
I think, yeah, Rob, do you have a question?
Well, I just wanted to ask one question, that particularly about bankruptcy proofs of claims, but also by the other liens you've been talking about. In our process, there are often cases where the workers are owed back wages, but the exact amount of the wages hasn't been determined yet. We're going through the our process. We go through substantial administrative procedures about about liability is being fought out. In the meantime, we don't have the exact amount of wages owed. Do we need the exact amount in order to file a proof of claim or these other liens? That's my question.
So for a proof of claim, you need a good faith estimate, and then you need to try to figure it out pretty quickly, right? But you can amend your proof of claim. It's not uncommon to file a proof of claim and then amend it. You need some basis for it. In say torts cases, it might be hard because you're just kind of making it up. I would think in the ALRB context, certainly in the labor commissioner context, we can usually come up with an audit, and we can come up with a number, and then we may say, oh, you know what, we got this wrong, we're going to fix it, right? So yeah, usually what we do in that situation is we file a proof of claim, and then we amend it as we get better information and clarify what's actually owed. And in some cases, we get into discussions with the employer about, well, that's not really right, so we should, and then maybe we essentially settle on a proof of claim number that agreed to be the right proof of claim number, right? And then for liens, at least in the mechanics lien context, which I have a lot of familiarity with, again, you need a good faith estimate. You don't need to get the exact number right. Mechanics liens happen really quickly. You have to file them within 90 days after the work, after the work of improvement is completed, which often means 90 days after the worker stopped working there. So often we have to go in with estimates and then try to clarify those as we're moving forward in the case. So it wouldn't be fatal, I don't think, that you only have an estimate, though you have to have some basis for the calculations and then be ready to refine it as you move forward.
Thank you.
And our general counsel had a question too.
Oh, yes, thank you so much. Yeah, so my question is on liens, specifically, because I'm thinking about whether there are ways for us to file mechanics liens for certain types of ag work, and I've never thought about that before, so that is something that I think we should look at to see if it would qualify for certain types of work. But prejudgment liens, I think, have a lot of potential because, as our board members have explained, we have this bifurcated process essentially where we don't determine liability, or we don't determine the amount of liability until way after liability has been established. And then once somebody knows they have a judgment, and then we have to go through a 2-year plus compliance process, that's a lot of time for them to offload their assets and divest. And that's what we see. And especially in some of our like what we call make-whole cases for bargaining remedies, the amounts are very large and they grow and grow and grow over time as the compliance proceeding is going forward. And that's where I think we have the biggest problem, and we've seen in other cases where they have so much time to plan that by the time we have the actual money judgment, they're gone, right? So I'm really thinking about what can we do pre-judgment, because most of them they don't own land. They lease land, and then the assets they have, I mean, crop liens are something I think we really, I want to learn more about and see if there is a way to get a crop lien. But other than that, I mean, their equipment usually isn't valuable enough to
Pay off all of what's owed.
to pay it all off.
Yeah.
So I guess any thoughts you have on that, what we could do pre-judgment for in the ag context would be, I'd really like to.
Well, let's talk about it maybe, offline a little bit, because I'm thinking about, there's accounts receivable. I mean, there's a whole host of things that are identified in the UCC as being available for a lien. And so not just real estate although real estate, obviously in California, is going to have the biggest money. And I think, you know, the question that Barry raised earlier around water rights, I mean, you can even lean, for example, like a 10-year lease has value. And so I think thinking about water rights is a creative pain point. But yeah, maybe let's talk offline about what are the assets available. Unless, Matt, you already have a list in your brain.
No, I'd have to dig into the ALRB context more. I mean, honestly,
me
I
too.
feel like I don't know enough about it. So I do think, yeah, it'd be good to talk offline about that.
Mhm.
I guess
Yeah,
the one thing I would say is that if you know that you can't possibly get any kinds of liens prejudgment, you have to then recognize in your case that you're going in a weaker position, right? I mean, it starts you off on the back foot. So it just is what it is. Then it's something you have to think
Yeah.
strategically about in your case.
Yeah, those
Yeah.
assets will just disappear. Yeah, which you just said. Yeah.
A note on that, just a quick note on that, because one thing I think and why you're seeing a lot of excitement around the liens is us trying to really figure out what we can do. You know, Ralph and I believe Barry to some extent, all in our prior lives, worked on SB 552 De Leon or 558, the wage theft bill. That gave a lot of tools to the labor commissioner. And I've, since I got here, been trying to understand what can we do that's similar? Like what if anything, did that open up for the general counsel and her team? In terms of other assets, I think, and I don't know, Julie, if this still falls under the category of not being worth the value, but I think some of the bigger players we have this custom harvester exception that was like very new to me. But in general, where operations will rent equipment that I think is fairly expensive from a custom harvester for a season, for a period of time. In terms of other, like you were talking about liquor licenses, you know, tasting rooms, obviously that's big in the wine grape industry. And I don't know if there's any way where you have grapes grown off site under maybe a different employer, but then feed into a tasting room, if there's a way to kind of make that connection. One thing we had discussed in other contexts is if there is any kind of universal license, certainly some employers use FLCs, but we have always had upchain liability. And not every employer uses an FLC. So like, there's not, unlike say the home healthcare or other industries, we have yet to identify like a universal or widespread license that a lot of ag employers use that could be of value. Like things that come to mind, I think sometimes, I think there may be an instance where like you do need a license to sell like a farmer's market or something like that. But I'm not aware of anything that the state itself issues that's ubiquitous across the industry, but things that we've been thinking about, I guess.
Totally. And you're in good company. I can't really think of very many industries where the state issues something that actually impacts the employer's ability to be in business. You know, Medicaid for retirement homes is relatively unique, but yeah, this is exactly the kind of creative thinking that we're trying to encourage.
And actually, one thing I would say just about licenses, because I've observed this over the years, it's important in the licensing context to make a distinction between licenses that customers care about and licenses that only other government agencies care about. Because in terms of leverage, the ones that customers care about are important to you. But if only other government agencies care about it, all you're really doing, right, is just shifting the enforcement burden to them, and they may or may not have the capacity to do it. So for instance, I've often found people say, well, let's suspend business licenses. And I look at my cases and I'm like,
nobody cares about business licenses.
Half of the businesses that that we have judgments against don't have business licenses. They don't care, right? Nobody's enforcing that, or it's not being consistently enforced. But things like contractors' licenses or security licenses matter because customers say, I won't do business with you unless you have that license. So, yeah.
You guys, let's look at a national context briefly, and then you guys can think about, you know, if you want to have us back or if you want to, you know, do some kind of like internal set of questions that, you know, we could answer in the future. We can think about how to proceed, because I can tell you guys are eager for this conversation, and it's a good one. And we're so excited that Ralph invited us. So I'm going to turn it to Justin to talk about our national understanding of prejudgment wage liens.
So hi, everyone. My name again is Justin McBride. I would teach in the labor studies program at UCLA and research wage theft. I feel a little outgunned. I'm the only one I think here who's not an attorney, so I will have no practical advice for you whatsoever about how to use these. But I do study wage theft policy and sort of the results of those policies and how they work. And some of that work has been in liens. So I'm going to talk a little bit today, particularly about a new law in the state of Washington that workers have been using and kind of what the effects have been for workers using those liens to try to collect. So currently 3 states have pretty broad access to workers to file pre-judgment liens kind of across industries. I think as Matt mentioned, almost every state has some form of mechanics lien available to construction workers. But Wisconsin, Maryland, and Washington are the 3 that kind of have opened that up to workers across sectors. And each state has a different kind of set of rules for sure. Wisconsin has the oldest system, Washington has the newest. Which passed in 2022, so very recent. A number of other states, including California and New York as well, have discussed extending lien rights, but haven't acted yet on that. We've been talking about it in California since back when I was a union organizer many years ago, so it's definitely come up and in the past. Can you go to the next slide, Tia? Yeah. So opponents to liens typically argue 3 things when they say that extending prejudgment liens are a bad idea. One is that they violate due process rights. One is that they'll increase litigation because folks who have liens levied against them are going to have to file lawsuits to get those liens lifted, essentially. And one is that they'll limit access to credit for small businesses. Basically, if I'm a small business owner, any worker could file a lien against me and I won't be able to get access to credit. The first 2 arguments, I don't think it's really worth talking about much. I mean, what's good for the goose is good for the gander, where I come from anyway, and mechanics liens are pretty broadly accepted, and those aren't issues in that one. The third one too, I'm not going to talk about a ton today, but I have published a study about this in the past and found that there is no impact to access to credit for small businesses. Looking at kind of the border between Virginia and Maryland at the time that Maryland passed its lien laws, and there's nothing there. We could talk more about this if folks are interested, but I don't want to belabor it. So you could go ahead and move on. So, and then, in California, it's something that may come up again. Policymakers are looking at it again in the wake of a 2024 state auditor report. The auditor is looking at the labor commissioner for a variety of reasons. But one of their primary findings is that expanding mechanics liens rights to all California workers would most likely improve the labor commissioner's ability to collect owed wages in a fast manner. So we're currently doing a study at the research lab on the effectiveness of mechanics liens laws here in California and the effectiveness of the new regime in Washington beyond the sort of construction sector. And I'm going to talk about that latter part now. So the law in Washington passed in 2022. It's very new, and it allows workers to file liens against either titled or real property in a wage dispute. So land, but also cars or accounts receivable and any sort of other thing that has value and that the employer owns. Workers can go back 2 years. So folks only really started using them in late 2023, early 2024. I mean, in theory, you could have filed one in January of 2022, but it would have been for a very small amount. And so really it's something that's very new in terms of activity in Washington. And it's set up such that employers are pretty widely defined. So you can file against the personal property of the owner of a tightly held corporation. You can also file against property where work was performed. And so most of the liens that have been filed have been done by security guards, housekeeping type staff or janitorial staff, and retail workers in Washington who are filing liens against the store where they were performing work as well. Seem to be the sectors where they've been most active in Washington. I should point out Washington has a crop lien law, which I don't study. And so that may be part of why it hasn't shown up in agriculture there. And initial data shows that things are moving pretty quickly in Washington once workers do file a lien. You can go to the next slide. So over half of the liens that have been filed in Washington since this new law kind of went into effect in the 7 most populous counties in Washington, which gets you down to about 200,000. Washington is obviously a much smaller state than California. Over half of those liens were released very quickly. And many of the ones that weren't released are less than a year old. So it's kind of hard to say again, because it's a relatively new thing there, but half of the liens were released in a very short amount of time. The presumption is that a worker doesn't release a lien until their collection is satisfied to their satisfaction, right? And so it seems to be a fairly safe assumption here. And only 3 liens in the state are older than a year in age. So I think that that's pretty interesting. Next slide. Most of the liens that have been filed that did release were settled in well under 4 months time. So there's a few that have taken longer that settled over a year even. But the vast majority of them settled under a year, and vast majority of those settled in under 4 months time. And so this seems to imply that they're moving very, very quickly. And then finally in Washington, Kings County, which is where Seattle is, makes the most data available. And the amounts that have been filed by workers have varied, but tend to be pretty small. And that may also help these settle quickly. So we're not talking about, $1 million judgments or anything like that. But they tend to be smaller judgments, and they're settling pretty quickly in Washington, sort of what the initial finding has been. So I'll go ahead and stop there. I think that's my last slide, right? Yeah.
It is, yeah. Yeah, thank you,
Cool.
Justin.
Yeah. Thank you
Economy
so
of
much.
phrasing. That was so swift.
Yeah.
If I can ask one quick question, you mentioned, Justin, at the beginning, what some of the types of workers that have filed these liens were. Could you touch on that again quickly? Which types of workers have filed these?
Yeah, I don't know for sure, but for every single one, but the ones that I have identified, there's several security guards, janitorial workers or house cleaning type work. There's one restaurant worker that filed it at a pizza parlor and filed it against, this was a case where the property was owned by another corporation than the corporation which the individual worked for. But both corporations had a common owner. And so he was able to file a lien against the property of the corporation because that's where the work was performed, and that was satisfied pretty quickly. And then in retail, there was one that was filed against a Ross Dress for Less, actually. And that one was also settled pretty quickly as well. So, but yeah, people tend to be filing these against places that have real assets, which makes sense. The whole point of a lien is securing a real asset. And so a lot of them have been filed in places where there's like kind of a third party where the labor was performed so far. Whether that third party is technically owned by the common principal, I don't know in all instances. I would have to look. But some appear to be a contractual relationship. So similar to an FLC situation where you have a third party that's the employer of record performing labor on some other business entirety's land. A lot of the liens seem to be pretty similar to that in Washington.
I would think security, right? Because it's generally going to be like a property services company, but the guard is at a business that doesn't directly employ them. Yeah.
Yeah, there's several that are from security companies for sure. Yeah.
Thank you.
Right. Do you all have any closing comments, and then I can open it up to questions? We may have some questions, not just from other board members, but and staff here, but also from our staff that are watching online.
No, I just want to say it's like such a pleasure to talk about this with you guys. It's a very like my husband does not like me to talk about it because it's very technical and boring, and so it's isolating. So this has been a real delight to see that there's so much appetite to talk about it. So let's open it up. Yeah.
Yeah, so that's a great segue because I'll exercise a point of privilege. I think this is something I remember starting as an attorney at DIR in a different context and meeting like the bankruptcy team in workers' comp and thinking, man, I just would never want to do that. But then over the course of time, really developing an appreciation for how critical this work is. And this is like where the rubber meets the road. I think there has been a lot of interest in generally in the public and I believe like kind of in the generation sort of entering the professional world in workers' rights issues and workers' rights. And so I guess what can we do to help encourage and build this pipeline? How can we get the next generation of Matt Cirolis and Tias and Justins? I guess if there's anything, because I think we would love this expertise. And there's just not as many people that are interested in it. I think when people think of going into the field of labor and employment or workers' rights, they're really thinking about, again, working as an organizer or kind of working on a frontline trial attorney, but this is such critical work too.
Yeah.
I'm just
No,
wondering
I
what
really
thoughts.
appreciate that. I really appreciate that question and think about it all the time. I'm sure Justin does too in the labor studies context where, we try to have 3 different tracks in labor studies. So we've got a research track, we've got a kind of a history track, and we've got like an organizing track. Did I get that right, Justin? Are there 3 places for people to enter the movement?
That's right. Yeah.
Okay, okay. And so that's what we're trying to do that, right? To create professional development, a space for research and for researchers. And some of those folks a disproportionate amount of our students end up going into law school. And I don't know if that's because they got interested in enforcing the law while in labor studies. But I think one of the things we can do certainly is create like internships, opportunities for people to get on the ground and get their feet wet. We have fellowship programs in labor studies. And so we have labor summer where, students receive for 10 weeks, they receive a stipend to go and be in the field. We have dream summer where undocumented students and allies similarly are receiving 10-week stipend to go and be in the field. We have externship opportunities and independent study opportunities, but really just socializing this, I think, is important. Like socializing that business associations, bankruptcy, like doing strategic research, doing research into business corporations and identities is sexy. That is the work. That is movement-based work is really critical. I don't know, Justin, if you want to say more, is holding a conference each year that you've now done twice.
Yeah, the Strategic Research Lab, this is a big part of what our program within labor studies does, is trying to encourage students to learn a love of research and understanding how better understanding of corporate structures can help workers see better outcomes when they organize or when they're suffering wage disputes or other kinds of power struggles. Yeah, we do. We're setting up a series of training programs for both students and movement people out of our labor studies program. So both facing our undergrads and publicly facing, including a labor research conference that we do every summer. We've had staff from the Labor Commissioner's Office attend that in the past, and that conference is sessions where you can learn discrete kind of research skills in greater depth around corporate research in particular. We also have other training programs where we're teaching researchers how to code and using tech skills or how to better understand industries as a whole instead of just corporations individually. So we're definitely trying to expand this within our labor studies program at UCLA.
Wonderful. Anything we can do to support those efforts, like if anyone in Hollywood's listening, give Matt Ciroli a reality show. Let's make him the Kim Kardashian. What Kim Kardashian did for criminal justice, we can make the Labor Commissioner's Office do for workers' rights justice, right?
No, photogenic.
That sounds like a very
Do
boring
it.
reality show. Sorry.
No,
Actually, I think it is exciting. It's interesting stuff, right? It's hard to get people to get over the technical barriers, and particularly if you have a kind of public interest bent as a lawyer, you're like, oh, I don't want to, this is all businessy stuff. I don't want to think about it. But it's interesting stuff because it really is how, it's how the economy works. At the end of the day, this is how the economy works. You got to understand it, not just with the bad actors, but even if you're, even if you're working with good actors, businesses, even businesses that are trying to comply, you got to sort of understand how the property finance and corporate legal systems work, because that's how business works. That's how the economy works.
I think also just not being afraid, you guys, like I'm so grateful that General Counsel asked questions because like encumber property left, right, and center, and they'll challenge, but the more expensive and difficult you make it for them to make that kind of defense, the better, the likelier you're going to get a good and early settlement. So kind of socializing the idea of as much as you can pre-judgment remedies is really important.
I'll turn over to see Santiago. While Member Flores is asking her question, Santiago, if you could look in the queue and see if anyone else in our audience wants to ask our panel questions, we will get to them after Member Flores.
Sorry, I didn't mean to jump in. If we want to go to public questions, that's totally fine.
No, it's okay. Go ahead, Member Flores.
Okay. So first, just thank you so much for taking the time and for providing us with such a thorough presentation, and really appreciate it. And so I asked the first question about which was the most effective recovery strategy or method. Is there like incidences where you employ or use multiple recovery strategies or methods at the same time? And is there kind of like an escalation kind of, or like a development of that strategy and how it kind of informs either the beginning, middle, or the end of trying to make somebody whole?
So I can answer that question. Yes, we often use multiple strategies at once. Think of it as a fairly three-dimensional strategic game. I mean, again, this is something that makes it interesting from the standpoint of just a lawyer practitioner. Often when you're focused on just litigating the case before you to judgment, you're thinking narrowly about issues, which can be interesting, interpretations of words. Does this legal argument fit? Does this legal argument fit? But when you start thinking about it in a bigger context, there's all these other moves that the opponents in a case can make, some of which can be challenged, some can't, you know, everything from bankruptcy to moving around corporate structure. So to be aware of all of these possibilities and the ways that you can sort of cut off those moves, like a you know, chess game, you're not just focusing on your pawns, you're focusing on the fact that, well, they can move their horse. And now that's starting to put, you know, how can I block it so that that's not going to be a move that they're going to be able to make, right? So it makes it kind of interesting just from the standpoint of lawyering to think about all of that. So we're often using all of that, all of the possibilities, and trying to think about the whole big picture. And then to be a little bit more precise, pre-judgment, more often than not, the two things that I'm focused on are who are we naming as defendants, right? And what are the theories for the liability of those defendants? Because the pre-judgment, I know that if I get a judgment, the only way really to enforce that judgment is to sell assets. So I want a defendant who has assets that I can sell, right? And if I don't have a defendant who has assets I can sell, if it's not possible, if there's no one's liable who's a defendant who has assets that I can sell, then I have to think strategically about the case. I'm in a very weak position to get money, right? It's unlikely I'm going to get money. Maybe there's other things we can do. Maybe there's businesses that we want to stop operating, but it changes so that's the one thing that I'm thinking about pre-judgment. Who are the defendants and what specifically, you know, are their assets and money streams? And then two, you know, can I get liens? I mean, really that, and it's in specific context, like the mechanics lien context, but that is extremely powerful. That's by far my best move. If I'm post-judgment, what do I do? Well, hopefully I've thought about all of this pre-judgment, and then I have some defendants who, if they don't have assets, at least did have assets and maybe fraudulently transferred those assets, right? And in that case, then I'm usually thinking about, okay, where did those assets go? Where did that money go? And often we are bringing civil litigation for fraudulent transfer. More generally, because we get this in the labor commissioner's office, I'll say we have a lot of cases that go through our wage process, through our Berman process, an administrative hearing process, and we have no input on those early on from the legal perspective. So we just get them after all this has happened. So we can't really think ahead of time. On those ones, the normal move, and I think this goes towards your question, is to try to broadly levy bank accounts. Maybe unless it's a sort of shut down corporation, in which case it's very unlikely they're going to have an active bank account, but broadly levy bank accounts, see if that, because that's a low hanging fruit. It's easy work to do. It hits about 30% of the time, I can say 33% of the time you'll hit, we hit. And then after that, it's, okay, so that didn't work. Now we have to really pull this case apart. Okay, who are the people? Where did the business go? What happened? What are our leverage points? And usually, who else are we going to have to sue? Because, right, the reason the levy didn't hit is because there aren't assets in the name of the judgment debtor.
And I just want to take this opportunity very quickly to say, where you don't have a pre-judgment remedy that's functional, those are hard conversations with your clients and with the workers, because it's very likely that they won't get anything at the end of the day. And so this is where policy solutions come into play. And so the more policy solutions focus on a pre-judgment remedy, a functional pre-judgment remedy, the likelier we are to see better outcomes, or any kind of remedy at all.
Thank you. Santiago, do we have anyone wishing to make public comment or ask questions of our presenters?
I'll ask that the folks in attendees. Oh, we have one hand. Kenya, I will unmute you and go ahead with your question, please.
Hi, good morning. Thank you so much for all the information. My general question was regarding cannabis growers. I understand that there might be some limitations with their ability to go bankrupt. And so I just wanted to see if there's any nuggets of information that you might be able to impart with regard to that sector of the industry, since there are distinctions, and it's very common for us to see cannabis growers go bust, or they'll close and they'll reopen, or then they'll run out of money. And so I'm just curious to see if you can provide any information in that context.
So I will start with the caveat that I'm no expert in that world in the cannabis grower industry, though I have run into a couple of these cases. I think from what I've seen, you're right. They tend to go bust. In part, it's the nature of the industry. You have a fair amount of people who come in with more desire to get rich than they have capital. So they may come in really heavily in debt and very thinly capitalized. And then the reality is they just don't have much money. They never had any money, right? But if there are successors, which I've seen this too, I think that's really your place to focus, right? Because you can keep chasing those successors and at the very least make it hard for them to ever operate in the industry again. So if they want to operate in the industry, they're going to have to deal with your claims and with their past, they're going to have to be held accountable for their past bad behavior. I think that's the best bet usually in the cannabis industry from what I've seen. I've rarely seen cannabis growers that actually own the property. They often are, leasing property. And in terms of bankruptcy on cannabis, I'm no expert, but you're right. Because of federal laws, the direct cannabis growers can't file bankruptcies. What I've seen is they'll file them in Canada and then do a bankruptcy. You can do a sort of stay in a U.S. bankruptcy court based on a Canadian bankruptcy filing.
Wow.
Your question makes me think that, there's important gaps in our knowledge here. Cannabis, other sort of lienable or leviable assets in ag specifically. So there's more research to be done.
Santiago, thank you. Do we have anyone else in our queue?
I don't see any hands raised. I'll ask if anyone in the attendee forum has a question to please raise their hand. No hands have been raised.
Okay. Well, I want to be respectful of everyone's time. Thank you so much. This was a really informative panel and discussion, and one where I think we have a lot of ideas percolating. Matt, I know you've been really gracious with your time over the years with us and our staff. I believe you did a training for our staff a little while ago. We would welcome the opportunity to talk with you all offline, both with the GC, I think, and with the board, and maybe see what we can brainstorm on. I also want to give special thanks to board member Lightstone. We've been talking about doing something like this since I got here and trying to structure it and get the right people. And I think, Ralph, you nailed it. And also to my assistant, Michaela, who also helped set this up and worked with all of you. So thank you so much for your time. I really appreciate it, and just very valuable information.
Thank you. It was fun.
Thank you very much.
Yeah.
Thank you so much.
Okay. All right, with that, we'll go on to our next agenda item, which is general public comment. I'll see Santiago. Is there anyone out there who wishes to make public comment?
Again, I'll invite folks who are in attendance. If you have public comment to make, please raise your hand to indicate your desire. Thank you. No requests for public comment at this time.
All right, and with that, it's 11:39. The board will recess into closed session at this time, and thank you.
All set.
Good afternoon. It is now 12:22 PM and the board has returned from closed session. Our next agenda item is announcements. The board will be meeting next week, Wednesday, March 26th at 10 AM, both on Zoom as well as here in Sacramento. We look forward to seeing you then. Thank you. This meeting is adjourned.